professionals in telecom, constitutional and administrative law, public affairs, and other related matters. Second, because it is also my way of sharing personal thoughts and ideas and weigh them. In other words, contrasting such ideas with those of my fellow panelists and trying to find connections and ultimately challenges to my own beliefs. Having said that, I would like to outline the main aspects of my intervention today. First, it is of critical importance to make it clear that my approach for today's agenda will be more of a critical approach to what I believe is the main issue: the transfer and use of our personal information in a high-tech society. That is, in a society where high-tech companies and devices are having a great impact in our behaviors as never seen before in history, where data is feeding both the interests of companies searching for high and lucrative returns and governments that are penetrating unexplored regions where they could have more information about their population and voters. Rather than discussing particular approaches under Mexican law to this problem, which I will defer entirely to my other colleagues in this table, and in most cases concur with their analysis, I have decided to discuss this topic under a more general framework and noting some of the current impacts that, in my personal opinions and views, this issue is generating nowadays, not only in Mexico, but in the rest of the world. For these purposes, I will divide my participation in three parts. First, I will review how this debate is relevant and yet critical to have it under the umbrella of a liberal society and the political principle related thereto, consisting of the ability of individuals to impose limits to arbitrary measures of those holding the power. On the second part, I will discuss how transfer and use of personal data is more of a sensitive problem when it comes to transferring our personal information to the governmental authorities, rather to other private entities, such as all other applications and online sites. Third, I will briefly examine how transferring our personal information in so many ways is reshaping our world, particularly nowadays in which we, along most of the population, are moving our lives online while facing the COVID-19 pandemic. So first, the liberal debate. In certain way, it is remarkable to have these discussions on how certain amendments to a statute may result in fundamental rights violations, particularly about the amendments of a statute that promotes the creation of a database that, under the official narrative, is aimed to be used by the Mexican government to prevent crimes such as phone call extortions and other offenses. It is remarkable, but nothing enough to remain comfortable, because we're yet still ruled by a constitution that frames the governmental action and its interaction with citizens and individuals. A constitution that, in the say of many Mexican experts, includes, in addition to social and democratic values, the principles of traditional liberalism, such as civil rights, division of powers, subjection to law, and very importantly, constitutional supremacy. It's remarkable because these are times in which authoritarian regimes are resurging or gaining more force and appeal as they may appear to solve certain collective problems more efficiently. For instance, the COVID-19 pandemic, but remain unclear on or non-transparent on the methods used for such purposes. But it is very important to have this debate here under the liberal umbrella, where individuals always have had the inalienable right to decide over the form of government that will be ruling them, and the right to oppose arbitrary measures that in their beliefs may hurt other basic rights such as liberty, freedom of speech, the right of privacy, and to remain safe or not being disturbed, including on their properties, their bodies, or intimacy, if not otherwise justified by the Constitution, among others. Sadly to say that in other parts of the world, even this debate could not be in the table for discussion. But here we are, assessing whether the creation of a cell phone users registry, or PANOUT, according to its acronym in Spanish, and the amendments to the Mexican telecom law may alter certain fundamental rights and other constitutional provisions. In accordance with most experts, the amendments to such statute and the users registry are unconstitutional, in essence, in three ways. First, because it's an unproportioned measure, as the creation of the PANOUT is not justified under the Constitution, as it will affect more rights and constitutional provisions than the issues that it will effectively try to solve. Second, the purposes for which PANOUT is created and its use will result in a breach of the presumption of innocence, as you just mentioned, Gabriel, as prosecutors may use such registry for the criminal investigations and imputations, while users may need to prove their innocence in a relevant crime. And three, it reaches fundamental rights of privacy, safeness, and no disturbance, as there are no assurances, neither institutional nor of any other type, that the personal information, including the biometrics, will be correctly used and remain secure and safeguarded. Further, experts also agree that the amendments to the telecom law creating the PANOUT affect institutional relationships among governmental agencies and contravene not only Mexican Constitution and Mexican law, but also international treaties and conventions adopted by the Mexican government. I believe that my colleagues in this panel will do a deeper analysis on these topics, or at least I am relying on the fact that they will do so, so I can move forward to the second part of my analysis. Now, I will discuss how transfer and use of personal data is more a sensitive problem when it comes to transferring our personal information to the government rather than to other private entities, such as all other applications and online sites, namely Facebook, Instagram, TikTok, Google, Amazon, or any other given app. Why do users feel less or no effective under fundamental rights when they transfer their personal information to such apps, and more vulnerable when such information is requested by the governmental authorities? Honestly, this is one of my main concerns, as I believe it has the same affectation. A third party having essential and intimate information about yourself, your biometrics, your preferences, political, romantic, sexual, musical, among others, and habits. For example, there are certain apps that measure our sleep habits nowadays. Why do we strongly oppose to provide government with relative similar information and preventively or automatically are willing to give it freely and irrevocably to private-owned online platforms and apps? My answer to this point is how our generation is dealing with the concept of trust. My impression is that under a liberal view, governments were created under the assumption that they needed to be framed and regulated because we distrust them. And by subjecting them to laws and rules, we may collectively trust them and cooperate in large scale. Based on historical experience, people that created modern states believed that power was something to be controlled and distrusted. Power ought to serve as a check to power, says one of the most quoted lines of Montesquieu. Why? Because in the past, humans experienced many abuses from uncontrolled power. Why? Because by setting a certain set of rules for interaction that could help us to exchange goods and live in a community in a pacific way, rather than killing ourselves. It is commonly accepted to think that such abuses from an era known as the Ancient Regime commenced to find a limit with the Carta Magna, which was the origin of the constitutional movement generated many years thereafter. The idea behind that those persons in charge of public affairs, such as kings, were required to behave under certain strict rules and limits has, perhaps, unconsciously made us believe that governments will use power against the people and not in favor of them, which is not necessarily true. This situation challenges many liberal, democratic, and traditional thoughts on the role of the state. As more constantly heard, we're facing a disruptive era, not only accelerated by the pandemic, but due to the great impact that technology and fintech are having in our lives. Will it be possible that, as Mark Zuckerberg said, the future is private? Can we say that we will need to rethink the idea of the state and government or constitutions, among others, and start thinking on how we will need to interact and frame social media or other data collectors so that ordinary people like all of us could live without the fear of a new kind of uncontrolled power and abuse of those collecting such information about us and everyone else. Another way to see it is that power, whether it is held by government or any other private entity, independently from the source, that is, the approval of the voters or the preferences of the market, shall be controlled by a set of rules that will help to prevent abuses, and by preventing such abuses, empowering common individuals in exchange. Nowadays, I believe there are no effective assurances that our personal information, regardless the creation of statutes and regulations on this matter, independently that such information is being held by the government or the private sector, will respect their correct use. We know for sure that each click, each like, each search or purchase we do online fits our profile with data that will be certainly used to induce our preferences to acquire more merchandise, be more likely to unconsciously accept ideas influenced by such preferences to the extent we may hold them as unquestionable facts, and alter our behaviors and interactions with the physical reality and other human beings. Personal information should be the object of more strict rules. This is one of the biggest problems and challenges we're facing nowadays that require a major collective action due to the unprecedented penetration that technology and the digital world is having in our high-tech societies. Some efforts have been made in the academic world. For example, The Age of Surveillance Capitalism by Shoshana Zuboff is a great reference in this debate. I think we all need to take these issues with more attention, keep learning and discussing as the way in which other agents, private or public, are collecting our data and how this will change the way the world will be ruled in the near future. On the last point of my intervention, I will be very brief. It is not a hyperbole when it's said that, quoting Yuval Harari in an article published in the Financial Times a few months ago, that we're moving life online. COVID-19 has accelerated this effect, which has shown us how literally vital and critical is to us nowadays to be connected to the internet, to have a smartphone, to have many other gadgets that are not anymore extravagant or devices that are not luxury artifacts anymore, but common life tools. We go to school, to work, to shop our groceries online. Traffic jams have been reduced and physical interactions in cities were in many ways decreased during the lockdown. Our lives went from one moment to another completely online. As being connected is a requirement to interact and form parts of this new world, a computer and a cell phone are basic elements to keep contact with others and keep working or keep learning at school. Moving life online may be an unstoppable tendency, which is not necessarily bad, as it could help some of us to be more efficient at doing our daily occupations. But what are governments and other companies doing? My guess is that they're using this unprecedented opportunity to debar our personal information from every single interaction that we have online. And it happens that there are millions of us online, many and many hours every day. This is a huge amount of data that will be processed and analyzed and used for purposes we can imagine, but not know for sure yet. And here's the problem and the connection among this topic and the cell phone users registry that the Mexican government is intending to create with personal information and biometrics of Mexican users. Collecting information about us may help us in many ways to solve daily life problems and have more time to do other things. But is this really happening? Mexican Congress says that creating the cell phone users registry with biometric information of all users will prevent the perpetration of crimes. Will it? To finalize, I will say that collecting personal information and biometrics may be good for many things and bad for others. It could be used to facilitate our workloads and prevent crimes, to know us better. But also, it could be used for surveillance and manipulation. The truth is that we don't know yet. In this sense, I entirely concur with Michel Foucault in his famous quote. It's not that everything is bad, but that everything is dangerous, which is not exactly the same as bad. My question here for all of you is, what do we do with things that we know for sure that are dangerous? Thank you very much.
Thank you, Gizeh. I think your presentation was very comprehensive, and you pointed out very sensible topics. Especially, I think it's very relevant to discuss more about the fact that private companies are collecting similar data that now the Mexican government is requiring. And also there are multiple implications. As you mentioned, Sobolev in her famous book, Surveillance Capitalism, talks about how this extractivism of personal data can deprive people of their right to decide their own future. And I think, as you said, liberal democracies are intended not just to control governmental power, but also private entities' power. But I would like to point out quickly and ask you your opinion about this. I think there's an important difference between providing personal data to private companies and also to providing this same personal data to the Mexican government through this PANOUT, as you mentioned, this National Cell Phone User Registry. The first one is when you provide this information, there's some sort of consent. I know, especially since your area of expertise is contract law, you can argue that it's not actual real consent, but it's some sort of consent. You decide whether you would like to have a Facebook account or an Instagram account or an Amazon account or not. But I think when the government asks you to provide this information in order for you to have a cell phone, it's not a consent situation. It's an obligation, a duty. This is very important. And the second point is the type of use that will be given to this same information and the types of implications. Like you said, there might be some implications to some of the values which we cherish the most, our personal liberty, our property, which people can be deprived just by enforcement officers using this type of information. So I would just like to know briefly your opinion about this.
Well, thank you, Gabriel. I think as I mentioned in my presentation that we're living in a very disruptive era. What we believe as evident truths and unquestionable facts, we're challenging all those ideas such as the government and traditional way of ruling ourselves. For instance, this concept of consent, right? You just mentioned that there's a big difference between consenting the use of certain app and transferring our data because we wanted to use such application, or the obligation that we have when the government tries to enforce the creation of this users registry, and we'll need to, we will not have an option to provide or not our personal information because we will still want to remain users of the mobile system, right? But it happens the same in the private sector. As life continues moving online, we'll need to interact. We are pushed to interact with other people and have our lives in these, apps and online sites, and we just can't decide, don't use them and try to do life as we used to do because we will not otherwise be part of this new world, right? So the options are very limited, and the concept of consent will be, we'll need to rethink that concept. And the idea here is it's all about a narrative. Who are the good guys and who are the bad guys in this story? We're used to think that government, because our history and experiences, are the bad guys because they have used law to punish and to persecute and to use the reign of terror to control people. But at least we have 300 years trying to frame such monster with constitutional provisions, with a system of governmental agencies rights to the people, so we can, put limit to them. But now we have another uncontrolled power that we have never seen before, which is not framed under this same game, and definitely, in my opinion, alters democratic values, and we should be aware that the new challenge is trying to find a way to control power in any way, either governmental or in the private sector.
You're absolutely right, and I agree with you. Thank you so much, Gizeh. We really enjoyed your presentation, and we really appreciate that you shared your time and your knowledge with us. And I also need to confess that Gizeh is a very good friend of mine. So I have a little bit of bias here maybe, but he's a very well experienced lawyer. And as you've seen, he knows a lot about this subject. So I need to follow with the next panelist, Miriam Heredia. She also happens to be a good friend of mine. She's a lawyer. She has a master's in human rights at ITAM, also my alma mater. She has a master's in justice studies at INACIPE. She has an LLM in humanitarian rights and humanitarian law, from the American University, and also a master's in public administration from Harvard Kennedy School. So Miriam, thanks a lot for being here with us. I would like to start with one question for you. In terms of security and law enforcement, do you think this PANOUT, this National User Cell Phone Registry, would be an effective policy in order to deter criminal offenses?
Thank you, Gabriel. And I just wanted to say, first of all, like, wow, what a way to start with what happened to your friend Nancy. If there's any way that any of us can help arguing about algorithmic bias, please don't hesitate to reach out to us. So, well, thank you, Gabriel, and the Berkeley Global Society for the kind invitation. I am truly honored to be sharing the floor with my fellow panelists. And thank you for the audience that is tuning in and taking the time to do so. So to ask your question, I think that we should start by asking the real question here, right? Which is, what is the true purpose of requesting our biometric data? We have heard multiple statements, made by congressmen, made by policymakers of this administration, and even the president himself, right, expressing that the main goal of the cell phone user registry is to prevent criminal conduct and to put an end to crimes such as extortion and kidnapping, and extortion, especially that comes from jail. Well, let me be crystal clear from the very start. These overbearing, repressive, and authoritarian measure will most definitely not deter any kind of criminal conduct. Furthermore, I think it would have a tremendous adverse effect. I mean, it will increase the crime rate and it will make way for the other type of crime to happen. And I'm going to break it down to you. So first, we need to address the systematic context of impunity in Mexico, because these type of measures that do not take into consideration the current challenges that we are facing in our criminal system, I mean, can be literally translated into like little band-aids for a death bleeding injury, to call it with all the letters, right? So like, for example, I wanted to take a few data because data is always good when we're discussing any matter, right? So according to INEGI's, our autonomous institute that does surveys in many matters, right? So according to INEGI's National Survey on Victimization in 2019, about 30 million crimes were committed in Mexico. 30 million. And 1 in every 3 houses had at least one victim. In this regard, if we analyze the criminal prevalence, we will find the following. Ranked in first place is robbery with a 27% rate. In second place are extortions with a 50% rate. And it is worth noting that extortions actually dropped from 2018 to 2019. In sixth place along with other crimes such as sexual offenses and other type of crimes, is kidnapping with an 8%. And the victimization cost in crimes like extortion or kidnapping are ranked almost at the very last position in comparison to other crimes. But what is even more interesting, if you dig a little more, we can observe 3 interesting facts. We will find that in 56% of the robbery cases, the item that was stolen was a cell phone. Even if 88% of extortions were committed using a mobile, the payment was only given in 8% of the cases. And 63% of kidnappings were done in less than 24 hours, is what we call the express kidnappings in Mexico. So keeping that information in mind, I tell myself 4 things, at least to myself. Maybe you will have a different point of view. This measure is actually incentivizing the most committed crime in the country, robbery of cell phones. I mean, criminals will always seek ways, to operate under false identities and any shielding mechanisms. So this measure will not have real deterrence effect. Secondly, it is pretending to tackle extortions that have been successful in only 8% of the times. Third, the economic cost of the population, coming from extortions and kidnapping is one of the lowest in the rank. So we cannot really argue that we are seeking the best interest for our victims, right? And if the kidnappings are done in less than 24 hours, I mean, the offenders would probably need the cell phone or their mobile not more than once or twice a day, putting in question, in my perspective, if law enforcement and security agencies could really take action in such a short period of time. I mean, frankly, for my personal standpoint, it would be a waste of the already low resources, I mean, both human and economic, that the law enforcement agencies have. And it would lead to investigations line that would lead nowhere, or at least to not the real perpetrator, like your friend Nancy, right? So that would be my first, take on answering your question.
Thank you, Miriam. I just need to make it clear that this was just a hypothetical situation that could happen with this new law. So it hasn't happened yet, but we have multiple cases in the United States with the use of this same technology where people are wrongly accused of committing a crime just because of facial recognition system misidentified them, especially people of color, where the bias is way higher. But I totally agree with you, but I would like for you to answer this next question. Do you foresee any particular impact that this measure could have in our criminal justice system?
Okay, so to answer that, I think I would make 2 points, right, to answer the question. So the first point is the one who leads us to the main issue at hand here, right? Our criminal system, our criminal justice system is rotten to the core. And I'll tell you why. The same INEGI survey states that the unrecorded crime rate, that is also known as the dark figure, is 92%. Is when an actual crime happened, well, or at least the person said that some type of crime happened, and there was no complaint or no investigation. That's the dark figure. But specifically, when it comes to extortion, this unrecorded rate increases to a 97%. So 97% of the people that suffer from some kind of extortion do not go to authorities to file a complaint. This means that the problem of insecurity in Mexico does not only comprise, the means that criminals use to take any criminal action, but actually addressing the lack of legitimacy that our law enforcement authorities have. I mean, if you look at this same survey that I think it has been going on for at least a decade now, the main reason behind not filing a complaint was because it took more than 6 or 7 hours to do so, to go to the attorney general or the district attorney to file the complaint. Because here in Mexico, the police agencies, not all of them can receive these complaints, which is a great mistake if you ask me, or that they just didn't trust the authorities, and they thought as well that they could be subjected to any kind of extortion as well. So it's more worrying, like if we even follow these crimes or these cases throughout the criminal process, because we will find that in 44% of the cases, nothing really happened or were not resolved. I mean, those with the complaint, in 44% of the times, nothing happened. And only 1% resulted in convictions. So criminals in Mexico have a 99% chance of not getting caught. But instead of working in capacity building projects or in budgeting or proper budgeting, our state officials prefer to pass on the burden to the rest of the population that does not engage in criminal activities, or to the concessionaries, and to an administrative institution such as IFETEL that will not have the budget to implement and deploy all the efforts that need to be poured in. So I can really make any argument that states in some form that this registry will actually help local enforcement authorities into fighting crime and putting an end to extortions and kidnapping. I mean, we have more than 10 national registries, the National Registry of Stolen Vehicles, Plataforma Mexico, the Registry of Enforced Disappearances and missing persons, the National Registry for a lot of things, but none of them are interconnected. So you cannot really, take all the intel and provide any proper assessment, or at least anything to do a proper comprehensive criminal policy in place. So that was the first point. And my second point, I would discuss, we have to discuss the cybersecurity implications here. We know that we can never be fully protected if we are connected to the internet. We know that. But have we thought about the tremendous risk that a registry with this type of information may face? Administrative and technical regulation is extremely important, the secondary regulation. And unfortunately, I consider that it's not gaining traction in most of the forums, right? So we need to put attention into this, because in every institution that I've worked for, and I've been working at the public sector for at least 10 years, we always had a lot of difficulties even having Microsoft Office licenses, in place. So now imagine when it comes to firewalls, to VPNs, to the servers, how are they going to manage, air gap? So what are the prevention strategies that will hinder any kind of cyber attack. And I seriously doubt that the IT department of IFETEL have, an incident response framework and knows how to mitigate any cyber kill chain or privilege escalation. I seriously doubt it. And this sets up to the fact that we do not have a national cybersecurity strategy as well. So we don't have any strategy at all. And then there's the issue of lacking the proper technological infrastructure and the absent coordination of authorities. I mean, what are the specifications or the mechanisms for sharing this biometric data that the IFETEL will have with law enforcement authorities such as the Attorney General or the Ministry of Security? Because the main aim was to tackle, crime and to deter crime. So you have to share that information. So how are you going to share it? We tried, I remember a while back, to devise and create a detainee consultation system that could be available to the public in order to prevent torture practices or enforce disappearances, in order to comply with an Inter-American human rights judgment. And it was almost impossible. I mean, because we had to connect our registration or our platform with the local authorities, right? So only 6 of the 32 states had the internet bandwidth and technical infrastructure to install the platform. Most of them had budget restraints to address the recommendation, and some other corporations, let's say, they were just reluctant to comply. So, I mean, for example, in 2020, the US, right, invested about 17 billion in cybersecurity related activities. I know we're not the US, and I know that we do not face the same threats. But let's keep in mind that even them, in 2015, you would remember, they had a tremendous hack at the Office of Management Personnel, exposing more than 21 million records of US employees. So, I mean, what are we going to do to protect our data? I think that is also a very important question that we need to address, and we need to ask for a proper and technical response for the authorities. And I mean, leadership, I think, sets the tone in cybersecurity, and I think now we're seeing a tone deaf in the matter, unfortunately.
Thank you very much for your presentation, Miriam. It has been very illuminating. I just like to highlight that she knows what she's talking about, because Miriam used to be the advisor to the Attorney General of the Republic in matters of human rights and international law. So she's very familiar with the system. And also, just to put things into perspective, Miriam just mentioned that the measure is not adequate to achieve the proposed objective that it tries to pursue. And I think it's completely absurd, if you think about it for a moment, that somebody will register his or her phone, and after that, that he or her will commit a crime with the same phone they were registered, right? So we need to be very skeptical about the supposed goal of this national cell phone user registry. And I think what Miriam just mentioned give us a lot of very important data and evidence that it is not going to achieve that objective, most certainly. And also that we need to be very skeptical, as I said, about this supposed objective. Thank you very much, Miriam. It was a pleasure to have you here. Next, I'm going to present our third panelist, Pablo Garcia. He works at the Mexican Supreme Court of Justice, where he clerks for Justice Franco. He graduated law school from ITAM. He has a master's in human rights in the same university, and he has an LLM in the University of Michigan Law School. Pablo is going to talk us about the relevant decisions of the Mexican Supreme Court in matters of privacy and geolocation. Thank you very much, Pablo, for being here. Please feel free to start whenever you like.
Thank you, Gabriel, and thank you to the Berkeley Global Society and to all the wonderful panelists that we have today. It's also great to see some old friends that, well, I hadn't seen in quite some time. I mean, you still look the same as I remember you, but I think it's a good way to begin, well, to re-encounter again and to see each other, at least in a, well, through this media. We will have to wait for a future reunion, I guess. That, I mean, hopefully we can do it live and present, all of us, and I think that will be better. And we can further discuss all these topics that are quite relevant and that are very important. And I think it's a good, great topic that we can talk about and share through different perspectives that we have in regards to what we do, what we're working for, and what we've worked before. So I'm going to be today talking about a bit of the, as you mentioned, Gabriel, about the Supreme Court's jurisprudence, basically with regards to privacy rights violations, and some of these matters. I'm sorry to be the party pooper because I won't be talking much about the relevant law, the relevant issue that we're here, and then actually, which is the main topic of this panel, but I'll be talking a bit about the references and I think, well, some ideas and some arguments that have been developed before by the court, and I'm sure that they will certainly be taken into consideration in any future litigations or cases that we might see with regards to this law. I mean, we've heard that there are some that are being prepared now, also by FISCAL, as Miriam mentioned before, that she brought it into consideration. So, I mean, there will be certain topics that will certainly be discussed in the future, and that these things I'm going to talk to you about, we will see them again, probably in a different dimension. But I guess it's important for you to understand what we're seeing and the context and how the Supreme Court actually reacts to these types of cases. No? I'm going to talk about basically two sets of decisions, one that were made through amparos, and another one that was seen in acción de inconstitucionalidad. I mean, for those of you that are not seeing us from here from Mexico, you know that amparo is much more of it's a concentrated constitutional mechanism, basically, which requires a complaint by a certain individual, while acciones de inconstitucionalidad are relevant to states. Well, it's basically state actions that challenge the constitutionality of any norm or any law that is enacted by Congress, basically. So, well, I'm first going to talk about the amparos en revisión. As you know, basically since 2014, in our federal telecommunications law, there exists an obligation for companies to telephone companies and telecommunications companies to register certain sensible information, as we could say, from its clients, basically. And there's also a duty to cooperate with authorities whenever this information is being asked for. You know? And well, this is established in Articles 189 and 190 of the Federal Telecommunications Law. And it defines a set of data that is relevant, which range from the most simple, maybe data that can be your name, for example, which, I mean, it also has quite it has a lot of relevance as well to what we see. But I mean, basically, it's not as sensible as maybe it could be your geographic position, no? Or the amount of the time that the call or registration of all the telephone calls that you have been made. So it has a lot of complex data, but it also sets a complex set of rules and obligations to consider for telephone companies. So these are basically these articles 189 and 190. I mean, they set a scenario of a complex cooperation, I would say, between authorities, private entities, the telephone companies I referred to, and any person that basically has a cell phone line. So what it establishes is that any person who has a cell phone line will have this information being tracked by its telephone company. So of course, obviously, this motivated a lot of amparos and challenges to this law. And well, the Mexican Supreme Court analyzed this case in a series of judgments that were enacted in the year 2016. These were the amparos en revisión 937, 2015, 964, 2015, and 1311, 2015. And what the court does in these judgments in the second chamber, which was the chamber of the court that was in charge of analyzing these cases, is they declare that both of these articles, 189 and 190 of the Federal Telecommunications Law, were constitutional. And they declare that these articles, even though all the information that they encounter companies to have, don't imply a violation to the right of privacy. And I guess it's very important to talk about the right of privacy now, and how does a court understand this right with regards to these cases, and how it regards as in different cases that I'm sure there will be relevant in the future. So the content of this right, I mean, it begins to develop it from a broad interpretation of Articles 1 and 16 of the Mexican Constitution, as well as with the court's own jurisprudence and the jurisprudence of the Inter-American Court of Human Rights. So when we talk about the right of privacy, we basically talk about the right that protects your inner self, if we can use this idea. No, it's something that, I mean, all people have activities that they like to share with public, maybe like this, like what we're talking right now. But of course, I'm sure that all of us, we also have activities that we don't want to expose to a public life or to a public spectrum. No? So the right to privacy, what it does is basically it protects anything that you don't want to share with an audience. And this can involve, of course, the activities that you might do at home, that you may do with your family, that even you might do at your office or your work. No? So anything basically that is not involving a public exposure will be, it's what is protected by this right to privacy. And I mean, of course, it also has different spectrums regarding the person that you're seeing, you're analyzing. But even with people that have public exposure, that are constantly being exposed, there's always a right to privacy that has to be kept secret, no? Or that has to be protected by the authorities. So, I mean, so this right also, I mean, as I'm saying, it coexists with a parallel obligation from the authorities to not intervene with these matters. No? So if there's any type of restriction to the right of privacy, then it will obviously have to be justified and will have to be analyzed. So when do we find a limit? And so where is a limit actually that authorities have to use this private information? And when is it justified to actually limit it? In the court here, well, the second chamber analyzes these articles and the set of data that is being asked for. And it clearly recognizes first of all that the right to privacy is not an unlimited right. That is always, it will always be okay, and it will always be fine to justify it with certain means, but you have to analyze things also very clearly, you know, and very with a lot of detail. In this case, of course, I mean, as it has been mentioned before by Polo and by Miriam, of course, the court considered that these two articles, specifically in the set of data that they were asking for, telephone companies, they were basically designed with a purpose to facilitate and become useful tools to fight crime. I mean, we can understand that cell phone tracking, I mean, it provides the authorities with a lot of information, but I mean, if it's used properly, it can definitely help to solve crime issues, criminal issues. And of course, I mean, this is information that will not only provide you the identity of the speakers or their name or anything, but also other sensible information such as the origin, the destination, location of the calls, or previous registries that might be useful if you're thinking about building a criminal case. So basically, this is the main idea, and this is a very important thing to take into consideration, because this idea of crime, the fighting against crime, is a justification that is being made in all of these cases, and that the court is taking very into consideration with how is it done. No? But so basically, this is the main idea, and this is one of the main arguments of why it recognizes that these two articles are constitutional. But there are some important disclaimers that I think are important to mention, and statements that all of these amparos make. They basically involve what are the limits to actually to this access by the authorities. So first of all, I mean, it establishes that the data basically received by telephone companies cannot be used for different purposes than the ones that are recognized by the law. And I mean, as Polo was mentioning a bit in his intervention, this is something relevant. It has to do a lot of how maybe your consent that we as users do or provide to cell phone companies to use our information in various ways. Sometimes we're not exactly sure where the limit is, but there's a general idea that this information that is being used by cell phone companies cannot be used for other purposes than from the one specifically that the law states. No? And I mean, of course, you know that there are very complex regulations and very complex rules of data protection laws that can also establish consequences for cell phone companies to not, if they misuse this information. But I mean, in the context of this decisions, basically what the court says is, this is an information that you need to keep private, that you need to keep to yourself. If one day we decide to use it because we have a criminal case against someone, then this is what you need to provide it for. And you need to give it to me in order so that I can act with this information, but there's an obligation that you, telephone company, have to keep it under your control. What the court concludes basically here is that this interference to private life is justified. I mean, it has a constitutional interest of being used to protect for personal security matters for people and with regards to its uses to crime generally. But it can also, I mean, the authority also has a limit to ask for this information, and this is something that recognizes what the second chamber also recognizes. It can only be used under the situations and conditions that are specified by Article 16 of the Mexican Constitution, which basically establishes a set of rules for interference with private communications, but that are being used in these cases also, considering the kind of like, well, the sensible information that is also being used, and that can be compared somehow to an intervention with private communications. So what the first control that kind of the Supreme Court recognizes here is that it has to be, first of all, authorized by a federal judge, only a federal judge, not local judges. Second of all, it can only be requested by a federal authority, which in this case, well, it's in charge of the Attorney General or National Prosecutor, or in cases of state law, with the local attorney. And this is also quite interesting because in several other decisions that have been analyzed, for example, in cases of enforced disappearances, a lot of states, for example, sometimes decide that, well, this is something that can be used by the local attorney, but also by other public servants from the attorney's local offices. And what the court has said is that no, basically this is a very strict control. This is a very strict measure that can only be used by local attorneys, not to work with other public servants from, even if they come from these offices. No? And second of all, the third control that basically it establishes is that it has to be specified with certain people, to certain specific persons, which that is being requested. It cannot be used basically in a broad way within an area, for example, but it has to target specific people. It also has to have a specific time frame, an amount of time. And also, there has to have, it can only be used with regards to criminal cases and not for other types of cases. No? So basically, cases that involve civil law, tax law, or labor law, etc., other fields of law, it cannot be used for. It can only be used for criminal purposes, which is basically the main idea of what we're seeing today, of what are the justifications that the legislators are doing actually to impose this type of restrictions to privacy law. No? And well, I'm going to jump to the second case, which basically involves, okay, well, how is this request meant to operate? How does it really operate in a criminal procedure case? And how is it really, how can it imply really a violation or not? And in this case, which is Acción de Inconstitucionalidad 10/2014, the Supreme Court analyzes Article 303 of the National Criminal Procedure Code. And this article, I mean, it gave a broad authorization to our Attorney General to ask for cell phone and telecommunications companies to unveil the live location of mobile devices that were related with any type of crime investigations. No? There was clearly no judicial authorization that was stated within this article. It was basically stated to be used by the Attorney General in a broad number of cases with all types of crimes, not just to specific crimes, but to all types of crimes that could be fought for. And what the Supreme Court finds in this decision that was made by the 11 of its justices is that this article is basically unconstitutional. No? And what the Supreme Court analyzes, of course, is that this is not something new. No, this is not a power that they hadn't analyzed before, and that, I mean, the trend basically is to have more of these cases where there will interventions will be requested, of course, by the Attorney General. So the court, I mean, previously it takes also some of the jurisprudence that the court had analyzed before, which involved the Federal Criminal Code. The Federal Criminal Code, which was enacted before our National Criminal Code, it granted this power before to the Attorney General. And in a previous case, it was also analyzed, and basically there are two main positions with regards if this encounters a right to privacy or not. basically there's a first idea that for people that think that there's not a violation to right of privacy, they kind of have the position that, okay, it's okay to ask for this information. It's okay for the state to actually take this information into consideration. There is still not a violation of the right to privacy because this is information that is being kept safe, apparently, but it won't be used unless it will only be used for a criminal case. And so as long as it's there, there won't be any restriction to a fundamental right. This is one perspective that the Supreme Court has with regard to this case. No? But under this no perspective, that this doesn't imply a violation to the right of privacy, the court still recognizes that this is an article that this case, the one that I was mentioning, it grants an unrestricted power to the Attorney General. So even though you might have this information that you can be used for, well, there of course needs to be a specific, there has to be a limit to the power the Attorney General can have to access this information and to request this information. And of course, in this type of case, I mean, it was basically stated that it didn't require any judicial authorization. It didn't need any type of control. It could be used for any type of criminal case. So, I mean, even under this no perspective that it doesn't imply a violation to the right of privacy, it was stated that, I mean, the court recognizes that the Attorney General couldn't have this unrestricted power, no? But I mean, under the yes perspective, basically, that this idea that this can imply actually a fundamental right violation, basically get to the same conclusion as well. That they arrive to a conclusion that is also unconstitutional by a different means, basically. That is also quite related as well, but I mean, it just takes a different type of arguments that are being analyzed. What they do basically under the perspective that there is a fundamental rights violation is to run basically a proportionality test. And as you know, I mean, proportionality test in constitutional lawyers, it basically requires a constitutional, first of all, a constitutional justification, but the means are basically what will define whether it can be constitutional or not to have this intervention. And in this case as well, it was quite obvious. I mean, even though it had a constitutional justification to fight against crime, it was still an unrestricted power that couldn't be actually recognized. So this is basically the conclusion that the court relies on for this case. Should state also that, well, before this case was discussed, which was in 2007, the article was modified by Congress in a 2006 reform that basically now establishes that the general rule for tracking and interference in cell phone location must always be subject to judicial authorization, not like it was previously enacted. And it can only be used by the Attorney General in specific cases. And in cases that, criminal cases as well, that involve a clear and present danger for someone's life, crimes that involve illegal restriction to liberty, such as, for example, enforced disappearances, or other crimes such as kidnapping, extortions, and cases of organized crime. It can only be requested only for these types of crimes. And of course, well, in the cases, the article now, the reform article, recognizes a limit to how the Attorney General can use it, only in cases where there is basically this clear and present danger, but it has a duty to inform a judge within the next 48 hours of when this measure is being used, so that the judicial authority can analyze and in case ratify this petition, for having this intervention. And I mean, it's something that's being used like constantly also you can see in other cases from judges and local authorities as well. I mean, I know that, for example, in cases of enforced disappearances, this is something that is quite used. For example, it is relevant actually for the purposes of fighting crime in some scenarios, and this is something that is being requested kind of like now immediately by any type of in cases of enforced disappearances and other types of crimes. I mean, I will conclude basically just trying to set some ground points that might be relevant for the discussion that we're having, that we will have also in the future. I mean, as you can see, the Supreme Court has established a certain standard for privacy restrictions, and what it has recognized, I mean, we can see basically in these two decisions, is that they will be allowed eventually, that there is a purpose actually to allow it. But the relevant thing is, well, what are you going to use this information for? I guess this is a very important question, Are you going to use it for crime prevention? And for what types of crimes are you going to use it? Can be used broadly for any type of crimes? And I mean, as you've seen, the court has actually kind of recognize that it has to be limited for specific cases and not only just to a broad scenario. No, obviously it has to follow a judicial confirmation. This is something. The request of this information cannot be used arbitrarily by the authorities, by the Attorney General's offices. But I think the main question, and this is something that is not being analyzed in the jurisprudence, and it hasn't been analyzed because it hasn't been challenged in this way, or it hasn't been encountered in this way, well, the main question I think for me is, what type of information can you ask for when you're actually doing this this intervention? No, like, what is the limit for the information you can ask? I can put a broad example. No, like, I mean, if telephone companies ask you, like, well, what is your sexual orientation, for example? I mean, it's a totally irrelevant question. It's a question that will probably be, if you take it to any court, they will say that, I mean, it clearly has a bias. It clearly has an intent maybe to discriminate or all. I mean, the cell phone companies don't necessarily need to know your sexual orientation, no? But I guess this is kind of like a very, like, well, it might be an absurd example, but this is just an example to show you guys that that there is not exactly a limit to where it can ask. You know? So I guess this is a first point that it's very relevant with the court's jurisprudence. That the court hasn't analyzed specifically what is the type of information that you will ask for, and it's something that I guess that will be it will be analyzed in future cases. But I think we shouldn't lose the perspective of what is the information that can be asked for. We always need to keep in mind what is the purpose of these reforms. What is the purpose of having this information, of encountering this violation to the right to privacy, establishing certain limits. I guess the court weighs a lot, as you've seen also, the purpose of what this information will be used for. And I guess these two ideas of what can it be used for and what is the information that they're being taken from you, I think that, like, this is basically the main two questions that should be asked with regards to these cases, I guess. And well, it's not answered completely. No, these are just two examples of basically what is the information that can be taken for and how can it be used. But I mean, we'll see how this question keeps on developing and what are the answers that will be provided by the courts in the future.
Thank you very much, Pablo. It's sometimes the attorneys that litigate constitutional law cases tend to forget that the court analyzed analogous cases before. So in order to make a solid argumentation, we need to consider these very important precedents that decisions that Pablo talked about. I would only like to ask you, Pablo, very briefly, am I right that the Supreme Court considered in one of these amparo and revisión cases that you just mentioned that live geolocation does not restrict the right to privacy?
I think it's a bit, I mean, it's under the perspective you see it somehow. No? In the amparos and revisión, the ones I mentioned, I mean, there were other violations, but I think the main idea had to do with the right to privacy. And it does consider that there is a violation to privacy rights. No, it does imply it. So, but of course, it also recognizes that the right to privacy is not an unlimited right. It's a right that can be also restricted in certain scenarios. No, which is the main question, basically, what we're talking about now. No, because how much can it be restricted? That, I guess, that's the question. And what are the means actually that you use to impose a restriction like that? So, but if you see it in the case of the acción de inconstitucionalidad, as I mentioned, kind of there's a two-sided decision, basically. You know, the one that says that recognizes, okay, this can impose a violation to the right to privacy, and the consequence of whether there is a restriction to the right to privacy is that you will have to run a proportionality test, basically, and see whether this restriction is justified, and it's basically done by the means that it is justified. But there's this also second perspective, kind of mentioned before, also, that this doesn't imply, I mean, the fact that the information is being taken, it doesn't materialize the violation of the right to privacy because it's still not used against you, kind of. No, that's kind of like the thing. It's information that is being kept, and that is being meant to be kept safely somehow by private telephone companies. In this case, in these cases that were being analyzed, and that there is a consequence for the misuse of this information that the court also recognizes. No? So for some, I mean, under these two perspectives, basically, I mean, there is not a violation to the right to privacy, but there can also be a violation to the right to privacy. Just depend, no? But I think the question really is regarding the means, no? With how is this restriction being imposed to you? I guess that's the main idea, but yeah.
Thank you so much, Pablo. We really appreciate you sharing your knowledge and your experience with us. As I mentioned, Pablo is a clerk for Justice Franco in the Mexican Supreme Court of Justice. So he really knows what he's talking about. Next, I would like to present all of you our next speaker, Dr. Saiph Sabash. She's the director of the HCI lab and the co-director of the UNAM, or National Autonomous University of Mexico, for those of you that don't know what UNAM means. So she's the co-director of the UNAM Civic Innovation Lab. She's also a visiting professor at the Human Computer Interaction Institute at Carnegie Mellon University. She has a very complete CV, so I would like to be brief. She's also a professor at UNAM. She holds a BA in computer engineering from UNAM, a master's and a PhD in computer science in University of California at Santa Barbara. And today, along with her colleague, Grecia Macias from RED, they will discuss some of the implications that this national registry has, both in the field of human rights and also in what they call techno-authoritarianism. Thank you both for being here with us. It's an honor, and please feel free to start whenever you like.
Thank you so much. It's such an honor to be here. Thank you very much, Gabriel, for the invitation. And also a huge thank you to Berkeley's Global Society. We're extremely excited to present. So I'm going to start sharing my screen. And one second. So we prepared some slides about this, the talk that we're going to be giving. Okay, do you guys see my slides?
Yes, we do.
Excellent. So welcome, everyone. I'm Dr. Savage, and today I will be presenting with Grecia Macias Llanas. She works at R3D, which is a civic innovation, which is a civic NGO which is fighting constantly for the digital rights in Mexico. And I'm here representing the Civic Innovation Lab at UNAM. And our backgrounds are, I have a much more technical background. I study computer engineering, and then I have a PhD and master's degree in computer science. I have worked in industry. I've worked in Microsoft Bing, also Intel Labs, and I've worked primarily in academia and computer science. And so I'm going to bring into this talk a technical perspective about how might this information, if it was hacked, used for nefarious purposes. Why is it dangerous that we give out this type of information? How might it also be used by governments for techno-authoritarianism? And Grecia, my collaborator, she's going to be presenting about the legal implications that this has. And so first, Grecia is going to provide us with a really nice overview about what are the legal implications, and then I'm going to jump in and talk about the technical aspects of this new padrón. And together, we're going to show you the perspectives about how it could be weaponized for evil, why you should be worried about it. And so this is an overview of the different things that we're going to be talking about. Grecia will be talking about all of these things about what exactly is in the law, how does it relate to privacy and freedom of speech, access to ICT, and presumption of innocence. And then I'm going to start talking about hackers and El Padrón. And I'm very interested in highlighting how it can be weaponized by bad actors, how it can be used for surveillance. And so now let me take it over to Grecia, who will start talking about these law implications, and then I'll jump in with the technical implications. And for me, what has been very important is to be able, is to combine engineering with law so that we can have a broader perspective about what is taking place in the world and then take action against that. And we've been aiming to do that at UNAM Civic Innovation Lab and with R13. Grecia, would you like to start?
Sure. Hi, my name is Grecia Macias. Thank you, Saiph, for kindly inviting me to this panel. Also, it's fun because one of the presidents that Pablo Garcia was just talking about was actually litigated by my NGO. So actually, I have some criticisms about that president, obviously, because I'm talking about things from my side of civil society and all that stuff. So it's really fun to have all these kind of multi-stakeholders and all these kind of visions here represented. Also, about what I just wanted to give a little bit of context before starting about the example that you told us, Gabriel, at the start of the presentation about that friend. Imagine a friend that Nancy. Actually, that is a reality now in Mexico. Coahuila and Aguascalientes are using facial recognition systems that we from our treaty are also challenging already. So that's not longer really far from happening here in Mexico. And it's really, really concerning because the technology that is being used is used as kind of is presented as neutral, while it could hardly, it is hardly neutral, and it could really impact on vulnerable groups' human rights. So let's talk about the surveillance context in Mexico. We do not have a good reputation talking about government surveillance, and that's the main concern when that we are always having here at R3D when we're talking about new surveillance initiatives from the government. Rather than, it is important to think about that, how this is not going to help to prevent or investigate crime, but also how it could be abused by the Mexican authorities. Also having in context that there has been multiple presidents from the Mexican government that have been abusing this kind of surveillance. Recently, we just presented a study with the newspaper El País that is called Fiscal y Espía, where our general attorney uses surveillance methods. Well, technically, it's for it's technology for geolocalization and all that stuff that is supposed to be used against crime, but it's actually but this technology has been used by some by some people that are trying to, I don't know, investigate journalists or trying to intimidate or investigate human rights defenders. We all remember what happened with Pegasus, right? And that kind of spyware that supposedly the Mexican government they told us that they were no longer using them, but recently in 2019 there was an activation of that software that was registered in Mexico. So we have a crisis when we are talking about the abuse of surveillance technology. So having this in context is really useful to know and understand the risks of this padrón. So I'm gonna try to share briefly my screen just to talk about a little bit more. Well, I think most of the of the panelists have gone through the main issues. Oh yeah. So yeah, one of the first issues that we observe from our treaties, that is centralized database. I mean, a centralized database that we are going to give really sensible data to the government, and also it's really vulnerable for, well, yeah, for vulnerabilities, right? It's not that somebody was talking about in the chat that oh, well, what can we say that, oh, to the people that says that, well, we are already giving our information to other government agencies, such as, for example, SAT, that is the equivalent of the IRS, right? But actually, I always say, like, well, two wrongs don't make a right, right? So that specifically biometric data is really sensible because it's not a password. Rather than a password, a numerical with letters password, you can change that, but you cannot change your iris. You cannot change your tone of voice. You cannot change, or you can hardly change your face, right? So that this kind of information is really, oh, sorry, I don't know what I'm doing. Well, it's really sensible for hackers, that my colleague Dr. Saiph is going to be expanding on that. But it's like a gold mine. It's like, and also we have the president that our government is not good at taking care of such centralized databases. We're recently hearing about leaks from different government agencies, and our data is being shared by hackers and different kind of nefarious people on the deepest spaces of the internet, right? Oh my, I think my I don't know what happened. So so that's really a kind of issue, that we don't want to give like all the identification system on only one database. That could make this kind of really have a really nefarious consequences when we're talking about our data protection and our privacy. Also, one of the main issues that we're observing here is that there is no judicial authorization for police and administrative authorities to access the database. So they can actually access such database whenever they want. They just have to write to the IFT, or our equivalents of the FCC here in Mexico, to ask for this information, and they're going to give it to them. As Pablo Garcia just said, when we're talking, one of the methods for adjudications here in Mexico, when we're talking about of proportionality and ponderation of rights, right? It's a test of proportionality, right? So one of the things that we actually challenge it when in one of the precedents that Pablo just mentioned is the lack of safeguards for these surveillance technologies. I mean, you cannot use this for an indefinite time. You have to be really specific that for the purpose and what are you trying to use that information. And always you have to you ask for a judicial authorization, because I mean, and again, with the precedents of surveillance here in Mexico, we also have investigated about how criminal organizations are working with government authorities, and government authorities are giving them access to these surveillance mechanisms. So here with the Padrón, we're just giving another tool for criminal organizations to surveil and, well, yeah, we're giving it the key to keep them keeping surveilling us and watching their enemies and all the people that they don't like. I mean, one of the main victims of, or the main people that are affected with these surveillance technologies are vulnerable groups, but in specific human rights defenders and journalists. I mean, one of the slides, I was talking about the chilling effect that some people kind of forget that it comes into the matter when we're talking about surveillance. Because obviously, if you see that, if you're a journalist and you know that your government is spying on you, you're not going to take much risks on your investigation. Rather, if you knew that your safety and your integrity is going to be secured, right? So that happened, for example, when we documented a case about Pegasus, where human rights defenders, journalists, and all political enemies from that government of Peña Nieto were targeted and were were victims of surveillance, right? So Mexico is a country extremely deadly for journalists and human rights defenders. So the right to anonymity is, for us, well, we can make, well, yeah, I really don't care that people know my name, or where am I right now on the internet. But for journalists or for some human rights defenders, the right of anonymity is a matter of life and death, you know, and these kind of technologies put them at risk, because now they're going to know their phone numbers. There could be like a target for more threats, for more intimidation, like I said, from government or from criminal organizations that are using this, that have these connections with government and are using these kind of tools, right? So that's a really important aspect to take into account when we're talking about surveillance technologies. It's not. I think that sometimes most of people try to pursue some technology with good faith, but I think we all know that the hell is paid with good intentions, right? So we cannot be we are not trying to say like, well, let's ban all technology and hate all these kind of innovations. No, but to recognize that no technology is neutral, that we cannot have this techno-solutionism to try to prevent or like using them like a magic wand to magically disappear all the delinquency and crime here in Mexico, right? So other things that are really, that some of my colleagues just stated, is there is one presumption in the law that is extremely concerning when we're talking about presumption of innocence, right? So what is the Article 180 bis, where there is a presumption that the one that is registered at this padrón is the one that is using the phone, right? So at first glance, you think, well, that what's the damage with that? But well, let's talk about what are the objectives of this law, like to persecuting crime and preventing crime, right? So basically, what it's doing is reversing the burden of proof to the state instance, so they have to prove that they're not the ones who make an extortion call, that they're not the ones that having using that line for criminal purposes, and that is a direct violation to our constitutional right to presumption of innocence, as in the Article 20 of the Constitution establishes that is the authorities' obligations to give the proof. They have the burden of proof to challenge, so they can challenge your innocence, right? Not otherwise. But here with this law, they're trying to reverse it, so they can easily like get rid of that requisite and more and open more investigations against citizens. And then again, taking back the context that we are having, where a lot of cases are fabricated, and that the criminal justice is used to punish the poor and the political adversaries, is a really difficult yeah, it's a really dangerous tool to have for the authorities, right? And also, when we're talking about access to ICT, we are not thinking about the vulnerable groups that cannot have the requisites that, or cannot give the requisites that this law is requiring them from them. For example, we're having about I wanted to share my slide again, but my computer is frozen. Anyways, so for example, migrants, for example, families with low income, for example, people with no homes, they can have they can have access to prepaid phones, right? But because sometimes are cheaper but they cannot have access, for example, having legal documentation, because sometimes the office is really far from their communities, or they don't have the money for that. Or for example, with people that have no homes, or an official localization, they cannot give like a receipt from the light, or a receipt from the phone that is required to get some of the documentation, right? So we are actually putting more requisites to access to these ICTs, and we are obstaculizing that vulnerable groups can be more connected and more safe within, safe, especially talking about migrants, that for them, having a cell phone is crucial for the security, because they are talking about which routes are safer, who to talk, and and what to prevent from or what routes to prevent that, so they can be more safer in their journey, right? So when we're talking about this, yes, we have to think about our privacy as individual citizens, but also let's not forget the vulnerable groups and the most affected people when we're talking about surveillance, such as I mentioned before, journalists and human rights defenders and women protesters and all that. And especially, like, I mean, we are not having this, right? This padron with biometric data. But actually, let's think about the thing that I mentioned when I started. We're also having facial recognition technologies. We're also having IMSI catchers or fake antenna that are used to surveil the public space. Think about not only how is it going to really be effective against crime, but also think about how the government is going to use them against their adversaries and against vulnerable groups. So that is going to be all for me. So I'm going to give Saiph the next part of our presentation.
Thanks so much, Grecia, and really great presentation. I really liked how you provided a history about what has the government been doing in this space and why should we be worried given all of the government's history. I'm going to share my screen now, and I'm going to start now presenting a little bit about, well, how might this data, for instance, be potentially weaponized for by nefarious actors for different purposes? Do you guys see my screen?
Yes.
Okay, perfect. Thank you. So some of the things to consider is that I think that this data can especially become dangerous when we considered that it can be triangulated with other existing data that exist. So for instance, recently, there was this huge Facebook hack with, I think it was over 66 million users whose Facebook data was hacked. And what this data had was their telephone number and a lot of information, public information that they had about themselves on Facebook. For instance, where they went to high school, who their sisters, brothers were, what type of food do they like, what type of places do they like to visit, etc. So I think that some of the things that could be done, for instance, by hackers, let's say that suddenly hackers get access to El Padrón. And I mean, this could be something that has happened before in the past in Mexico, where you have bad actors that are taking hold of the data. So let's say that suddenly hackers have access to your biometrical data. How might this be used for evil purposes? Well, let's say, for instance, somebody, even the government or a business, has cameras on the street. They could start to use the cameras to identify, for instance, people who are coming in and out of their gym, coming in and out of their restaurant, identify them by their face, and then have them linked to a phone number. And then by using the Facebook data that they already have, they're able to identify, oh, this person who I might usually just have known that they came to my gym. Now I know who their sisters are, where they went to high school. You can imagine, for instance, kidnappers using that information to call people up and then do other types of extortions, because they can easily say, hey, I have your brother, and to prove to you that I have him, we know that he went to high school here. We know that we've also kidnapped his sister, etc. And so they can provide you now with more information, so that the third parties could be very scared, because they might realize that, oh, they might really have him. Or, for instance, it could also be used. I was actually imagining, for instance, cases where you could feed this data into a machine learning model and then suddenly start to use it for virtual reality. And in virtual reality cases, you can think that somebody is navigating the street, and then suddenly they might be faced with the face of somebody, and then instantly they have access to information such as where they went to high school, where they work, and through that information, it can highlight to the person, oh, you know what, this individual is likely making a certain income. They are likely from this certain social status. They're worthy of being kidnapped. And so I think that you really have to think about how this data can be weaponized and triangulated with other sources for nefarious purposes. Now, other things that were also discussed is it's very important to understand that machine learning models, for instance, they get fed biometrical data, and through this biometrical data, they start to recognize, for instance, oh, this is Bob, this is not Bob. However, a lot of this biometrical data in these machine learning models, here's the pipeline actually about how those machine learning models work. They have biases, as another of you were discussing. They have biases in how they operate. How do those biases impact what happens? Well, maybe, for instance, some of the raw data that you use to train your machine learning model, you didn't actually get a lot of people of color. And so your machine learning model is actually not very good at differentiating for instance, a brown person who is from Oaxaca from a brown person who's also from Oaxaca, but maybe another community, and who have maybe like darker skin. Maybe your machine learning model is just not able, because it didn't receive enough raw data, it wasn't able to differentiate Juan Perez from Alberto Ramirez, and maybe Alberto Ramirez is a serial killer, but Juan Perez is innocent. But because your machine learning model was not fed enough raw data about people of color, your machine learning model is going to have errors in who it is detecting that might have committed a crime. And so this becomes problematic, especially when you might have, for instance, lawyers, policymakers who are not aware about the biases that can exist in these systems and how they might not be optimized for people of color. And so maybe this a court judge could say, oh, yes, of course, the machine learning model recognized that Juan Perez was a serial killer, but they're not thinking like, oh, what type of biases exist in this machine learning model that led to that classification that might be incorrect. And so I think on the other hand, it's important for us to realize that there are a number of biases that exist in the pipeline of the machine learning model that is learning through time faces, for instance, recognizing Bob over Juan, etc. There are biases, and there are different biases that exist not only in the raw data that is fed, but also in the type of features that you get. And so another thing to consider when we're thinking about this is that you can't change your fingerprints. So for instance, maybe like what happened with Facebook, who allegedly has really strong privacy measures. Facebook's data was hacked. Well, you could say, yeah, you know what, I'm just going to change my phone so people don't know with my phone number all of the private information from Facebook that I have. Great. You could do that. But what happens when you have your biometrical data linked to it? You can't change your fingerprints. So it means that when your biometrical data is hacked, anyone can suddenly impersonate you, and you cannot change this. It means that they can steal your identity or even implicate you in a crime. So another thing is that, as we mentioned, it can be used to track people without their knowledge or to drive criminal investigations or prosecutions. For instance, as we mentioned, it could be that a person has cameras installed outside their business. And through those cameras, they are spying on the people that are going through their business. You could think it's even maybe the government who's going after some of their political enemies. And suddenly, before they might have had to invest a lot of time in understanding who are the people that are passing through their building, who are they connected with. By, for instance, triangulating with Facebook's data, they might be able to realize, oh yeah, that's Mary Smith. And Mary Smith is actually an attorney who is also working here. You know what? We also saw that Mary Smith maybe was helping out in this activism on the street. And she's actually a high-powered attorney. You know what? Let's go to her law firm and criticize her so that she loses her job. I mean, this is actually something that has started to happen, right? We had, for instance, women who were helping allegedly activists in Mexico, bringing them water. And then suddenly the government came out and said, hey, we know that this woman is part of this law firm, and this woman actually lost her job. And so this is not a far-fetched reality. This type of technology could very well be used by these different government actors to further surveil individuals. And so finally, to finalize, if you're interested in maybe taking action around this, starting to do something, we invite you to visit this page of noalpadron.mx, and you can submit your message to Mexico's Comisión Nacional de los Derechos Humanos to say that, no, you are opposing to this padrón. This website was made by R3D, and it has a lot of support from different organizations. And it's a way in which you can start to take action and do something if you think that this padrón is not something that you would want to see in Mexico. Or to stop it, because now it's going to be implemented. So thank you so much. It was such a pleasure to collaborate here with all of you. And yes. Oh, and am I sharing? Oh, did I stop sharing my screen? Sorry.
Yeah, it's okay.
Okay. Oh, that's so sad. I'm so sorry. Okay. Yeah. So that was my talk.
Thank you both,
and just a
Dr.
Just a brief advertisement on such page on Monday. We will publish our amparo, and we'll talk about further how you as a citizen can use an amparo so you can challenge that law. And that's all.
Thank you both, Dr. Saiph and Grecia. It was a very comprehensive talk, and I think you mentioned the multiple implications that this type of legislation will have, in my opinion, because I agree with you. And just a quick comment regarding the last part of the presentation. We might see these scenarios like dystopian scenarios, and we think that this can never become a reality. But if you just take a look at the social credit system in China, I think you will be more aware of what type of implications regarding social control and authoritarian policies can bring about this type of legislation. So thank you both very much. Next, we have our next speaker is Gamelyn Oduardo-Sierra. He's a Puerto Rican lawyer. He is a very experienced speaker in multiple academic institutions in Latin America. He went to law school at Universidad de Puerto Rico, where he also has an MA in cultural administration. He has also an LLM from UC Berkeley, my other alma mater. And he's also a very interesting character, I might add. He's a bright attorney, but he has a multiple interest. And he's very much involved in political activism. So just to give you a quick context, Gamelyn and I, we met in the summer of 2018, just before the Mexican elections. And we had a lot of conversations about the current Mexican president, who by then was just a candidate, Andrés Manuel López Obrador. And I think my first question for Gamelyn would be, what would your comparison from what we thought back then and right now, from the general Mexican context and also from our current president is? Welcome, Gamelyn.
Thank you, Gabriel, the other panelists, Berkeley Global Society, Alvin, for having me here to talk about this very important subject. I first need to say that I'm always careful when commenting on Mexican policy issues. I am not Mexican. And being a foreigner, you know, the Mexican Constitution has this provision that we cannot intervene or interfere in political issues. And this is a very political issue, but I've done it before. I have been a supporter of the current president from the moment where he was a candidate, as Gabriel said. And I have also supported various social movements in Mexico in my career as a lawyer, and while I was a student at the Yo Soy 132 and all of these other movements, Movimiento de Resistencia Juvenil en Querétaro, and also labor unions in Mexico. So I really hope that my solidarity with Mexico and also my personal academic and professional relationships with people in Mexico forgive the very unconstitutional remarks that I am about to make as a foreigner commenting on Mexican politics.
Thank you, Gamelyn.
Yeah.
In general terms, how do you see this national cell phone user registry in the present context of Mexico?
Well, in the present context of Mexico and the world, I think it is a little troubling, as during the last year, we've all moved our lives professionally, personally, and socially, and otherwise through devices like the ones I have here, my kids. We are living through our cell phones. For the first time in a lot of time, in all of the years that I have had a cell phone since I'm a kid, I got a call from a man with a woman crying in the background saying that he was gonna disappear my daughter. It was funny, you know, and I hung up after saying a couple of things. I said my piece there, but I have 2 kids, I don't have a daughter. So extortion is real, and it is a problem in Mexico and all around the world. Like with all criminal issues, there is this analogy that in trying to eliminate crime, we have to use tools. And when using tools, I like to think of a hammer. So when I have to nail something, I use a hammer. But if I nail it and the nail doesn't go through, I might have to buy a heavier hammer. I might have to buy a heavy duty industrial hammer. And in that effort, I might end up buying a hammer that I can't even lift in order to use. I think this is a problem that could very fairly be happening with a registry like the one that it is proposed. But there is another problem that has nothing to do with law enforcement and its problems. It's the problem of surveillance. And, you know, after listening to what the compañeros and compañeras have said, I wish I could just turn off my iPhone and turn off my computer right now, because it's crazy what they can do while we're online. So there's another problem. This guy who called me, he got my number from somewhere. And I try to not be that friend that freaks out about the global conspiracy of our numbers or our information. But I do recognize that it is a problem. Anyone that has taken a course on cybersecurity knows that every time you pay for something, every time you sign up for whatever, even, you know, socialist groups in the United States, you know, I put my email here and I'm bombarded. I get information from everywhere. And even while I'm talking with my wife here at home about getting some hiking shoes, they suddenly come up in my browser. So when we put information around our devices, or we just put them in to buy something, this and that, we know that that information is out there. It's up for grabs in the confines of the dark web. And that information separately or all together in a centralized registry, it costs money and it's worth billions of dollars. So the registry itself seems to me like an act of extortion. We call extortion when someone attempts to obtain money or property by threatening to commit violence. As I said, we have carried out our public, personal, professional lives during this pandemic largely through our telephones. So now if you want to live in Mexico, if you want to live your life, if you want to go to school, if you want to work, you need to give the government your personal information. That could very well include your iris. It could very well include your facial recognition. It could very well include your dactilares. And there's some people who said, well, you already gave this to Apple, for example. You know, I didn't buy my Apple phone until I heard their defense that, you know, that's actually staying in my phone. And I know I'm protected by the 4th Amendment of the US Constitution with regards to my phone. So after I knew that, then I'm like, okay, this is not gonna, my face is not gonna be, my fingerprints are not gonna be in the database of Apple. So I might as well buy it. But that is a decision some of us make. It could be because, you know, we are paranoid, but we are paranoid because of a reason. You know, this writer, Walt Whitman, they said, yo, he died, he committed suicide because he was paranoid. After years with the FOIA requests, we know that he wasn't paranoid. He was being followed all of his life, and that took his life. So it depends on the grade of paranoia that you have. You know, I like to think of myself as having like a medium tolerance to paranoia. So that's just me. But this is a very violent proposition. Even more so, you know, having to give your data to use a cell phone to be ordered to contract the services of a cell phone provider, it's a pretty violent proposition, and even more so in a country that recognizes access to technology and information and the internet as a fundamental human right. And this is one of the most beautiful parts of the Mexican Constitution, because it means that the Mexican Constitution is alive, and it started raining here. So if you hear the noise, I'm sorry for that, but I can't really help it. So being a fundamental right that you're threatening to take away, I think that's very, very violent on the part of the Mexican state. The fact that the Mexican Constitution is a living document is more than I can say about the United States Constitution. It's more than I can say about the Puerto Rican Constitution. So if it is more than I can say about those two constitutions that I vow to defend as an attorney, then I think that you, as Mexicans, should very well defend the rights stated in that constitution. Gabriel was supposed to ask about how this compares to things in the United States. Okay.
Yeah, go ahead. Just a quick comment, Gamelyn. I'm sorry to interrupt.
Yeah.
Since this event is taking place mostly in Mexico, and we are not very big fans of starting and ending things at the exact right times, we're taking a few minutes more in order to finish the presentations. And after that, we'll have a Q&A section. So please, kindly, we ask that you stay with us. And please go ahead, Gamelyn, make your comparison between the United States situation and the Mexican situation.
We're in Mexico, Puerto Rico time. So it's always 15 minutes behind. We started on time, so that's has to worth something, you know. Constitutions, I've dedicated my life to studying constitutions, and I was just reading the Mexican one, and it's beautiful. But I'm gonna talk about the Puerto Rican and the American constitutions. They're a product of their times. We're all here attorneys, you know, some of us, and we know that constitutions are products of their times. But in some countries like the United States, they're obsessed with a constitution that's fixed in time. There are people who call themselves originalists because they want to put themselves in the shoes of the founding fathers when analyzing the social conundrums of the present and the future. So the United States Constitution was drafted in 1787, almost a century before a telephone even got a patent in the United States, which was Alexander Graham Bell's patent. Okay, so legislative, and with regards to biometric data, legislative action in the United States has been concentrated in attempting to control private actors' collection, retention, disclosure, and destruction of these biometric data, not on the state's use and collection of this data. As a matter of fact, I was just checking, you know, because I have my paranoia on high with this talk today. And the Department of Homeland Security brags in their website of having a repository with 260 million unique identities. And they process about more than 350,000 biometric transactions per day. Some of those have to do with the war against terror. You know, there are less than 260 million citizens in the United States. So they don't only have our data as citizens, they probably have yours too. So, and they use that to enforce the border protection, as they call it. You know, I like to, you know, to get Latinos into the treatment camps, in other words. They use this data to enforce their local policing and federal policing in the United States. And we know, because that's what we've been talking about in the United States for the last couple of years with Michel R, the new Jim Crow. We know who are the people who bear the brunt of policing in the United States, and that is minorities, Black, brown people, people of color, and people who are not the typical white Anglo-Saxon person in the United States, white people. So knowing this, with regards to phones, the jurisprudence has actually adapted to the times. And it, you know, the right to privacy is not in the US Constitution. It's recognized by jurisprudence from the penumbras of other rights. So this is something that has also happened with phones and this data that citizens store in their phones. There's this Riley versus California case in which the Supreme Court of the United States says basically, okay, you can search a person's phone, but you need to get a warrant because there's so much information in those phones that it's not like the ordinary phone. Like, you know, you remember when the phones came out, we used to just text and call. And if you call me, it's better because I don't need to pay. But it's different now. We have basically little personal computers that we carry around all day. We have little personal watches that we carry around all day, tracking where we run, tracking where we eat, tracking what we eat. where I can order food from my watch and my phone. So it's so much more of an invasion of privacy than it could have been in the past, okay? There's also the protection of the Fourth Amendment with regards to cell phone location data. And that's the case of Carpenter versus the United States. To get the information of the data, the georeferencing of my cell phone, to know where I ran this morning and who I texted when I got out of running, telling her I'll be right there. Don't worry, I'm gonna take care of breakfast for the kids. In order to get that data of the cell phone tower that received that message and sent it to my wife, they need to get a court order. And it's only fair. It's only fair. In Puerto Rico, there is this case of the most famous anchorman in the Puerto Rican news, whose name is Carlos Weber. He's an exile from Chile and came to Puerto Rico and did his career here. And he's like, great dude. He's a great dude. He found out that the Negociado de Investigaciones Especiales asked for his cell phone company to give them all of the information of the calls that he made. This was early 2000s, okay? So they probably got texts, they probably got calls to and fro. They weren't able to get probably all of the information you can get for a cell phone right now. The case was decided like a decade after, but this case decided that even before asking for a third party the information about your phone and the calls you're making, they need to get a warrant. To get a warrant, you need a reasonable cause. You need to go to a magistrate. You need to go to court and get this warrant. It's not, and in this case, particularly protecting journalists, and Carlos Weber is a great investigative journalist, so he was definitely gonna be a target today or tomorrow, and he's still a target today. They need to notify the person of whom data they are asking. So it's not like Negociado de Investigaciones goes to court and gets this subpoena without notifying the person. They need to notify the person, and the person has a right to defend his data and his personal information in a court, and they need to justify why they want this information. And then I have my due process rights as a citizen to say, no, I don't want you to have this information. And the judge then decides, okay? So what is proposed, what is proposed in the case of the Mexican registry, that you can go and obtain all of this information without a court order. I mean, the Mexican registry is a free-for-all would be a free-for-all for law enforcement agencies, and that is a problem. That is very, 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 very dangerous. Even if I were supporting López Obrador and the current government, I would govern and I would say, and I would make policy thinking of if I wasn't gonna be in power tomorrow. Thinking as if you're gonna be the political dissident tomorrow, as you were for so many years, because you were the political dissidents. They stole the election, everything. We know everything that happened. But you need to govern as if you were going to be in that position tomorrow. You always think of the worst case scenario. And I don't think that they are thinking of the worst case scenario here. The worst case scenario here is that citizens are going to be presumed criminals. And even more so, if a crime is committed with your cell phone, then there's a presumption that the person in whose name is the cell phone did this. What's the problem with presumptions in the legal field? The problem with presumptions is that I need to rebate them. I need a lawyer to rebate this presumption. And guess who can't get a lawyer? In the United States or in Mexico or anywhere. Who has more problems with access to justice? People from the working class. So you're saying that you're the working class president, the working class governor, and you're pushing this policy that and if you don't know, we're telling you, is gonna affect people from the working class who are gonna need access to justice, who are gonna need to get an attorney to defend against an unjust presumption. Based on what? Okay, so we can only imagine, you know, and that's people like civil people who have nothing to do with politics. We can only imagine what this could mean for social movements. We can only imagine what this could mean for journalists. Knowing the problem of the journalists in Mexico and in the United States and in other Latin American countries, that the government can obtain personal information of mobile phone users that includes your biometric data without a court order is definitely going to create a chilling effect in speech. You know, this is, I don't know if this is why they're doing it, but you need to know while pushing policy that this is gonna happen. It's gonna prevent social movements from expressing what they wanna express. It's gonna prevent journalists from calling whoever they want to call to get their news out. And it is going to be a major problem. It's going to become the hammer that you can't even raise in order to nail the nail down. Okay?
You're absolutely right, Gamelyn. I don't know if any of you have watched this video from a BBC journalist in China, where he challenges Chinese authorities to identify him. He's in a big city. I don't know if it's Beijing or some other big city in China. And it only takes 7 minutes for the police officers to track him down. So, I mean, just the fact to feel surveilled for a journalist will have definitely this chilling effect you're talking about. One last question, Gamelyn. What do you think will be the future for this padrón, this panout in Mexico?
When you said that thing of the 7 minutes, I had to look at the lock on my door, and it's locked. Okay. I was talking to a good friend who's also a Berkeley student. I think he's a student right now. He's finishing his LLM over there, Carlos Davila Peniche. I don't know if he's online or not. Still, we were talking about what the future would be, and we already discussed it here. Maybe constitutional remedies will be sought by agencies. Maybe it's gonna rain amparos. We already have here the people who are writing. Probably you definitely have it right now, and you just need to present it on Monday, you know, because it's Friday and we need to chill or try to. So next Monday, this rain is gonna start, the reign of the amparos. But I asked him, as an attorney, what can you say? Is this is this gonna be stopped so that no name has to be included in the registry? And he gave me a really attorney question, an attorney answer. It depends, okay? So it's gonna depend on what the courts decide. It's gonna depend on if they stop it or if they ask for injunctive relief, because law, el derecho es rogado, so you need to ask for whatever remedy that you want. But I think that it also depends on if Mexican citizens make it an issue. And I definitely think that they should. I'm happy that there's a website saying no al padrón. I think that that's the way to go. There has to be a movement in the street to support whatever you think should happen with regards to policy. So I think that is very, I'm very hopeful that you guys can stop this. I have to say that I don't agree with the registry, and I don't agree with the registry in Mexico. And if it were going to happen here, I wouldn't agree with the registry. I can't agree with the registry. In a country, for example, like Mexico, we were explaining before how I think it was Miriam who was explaining before the levels of impunity. And I felt really identified because of the levels of impunity. In Puerto Rico, we call it La Isla del Crimen. So the level of impunity here is like people do whatever they want. because you know you're not gonna get caught, okay? And it looks like being on the state side of things, it's even worse, because the state in Mexico just banished 43 people into thin air, students. Like, and what's happened? I don't know. The state of Mexico, you know, with its negligence in not taking care of what it needs to take care of, caused the death of tens of people the other day in the accident in the metro. You know, that doesn't happen in Germany. That doesn't happen in other countries that like to take care of their stuff. If that happened to the metro, that's a very important part of the Mexican transportation system. If that happened to those 43 kids, what can happen to our privacy? What can happen to our personal information if we put it there? And we already know, because we already know that there was a prior registry, and we know that ended up in the dark web. So we know, we have already seen this movie. This movie, we already saw it, you know, and I'm not like my kids. My kids like to see movies, Moana, I want to see it 25,000 times. I want to see a movie, and then I want to move on to the next one, you know? And this movie is one that we already saw. And I want to finish by thanking Gabriel for the extraordinary work that he's doing, the Berkeley Global Society, the audience, and all the other panelists. This has been beautiful and a great opportunity. Thank you very much.
Thank you, Gamelyn. We're pleased to have you here and to learn from you. I think so too, that we should be optimistic in terms of what would happen to this legal reform. If you remember, one of the comments that DM Chemerinsky from Berkeley Law, who is probably one of the most respected constitutional law scholars in the United States, he always says that whenever a judge that will analyze a case can put his or herself in the place of the person that is affected by this legislation, the outcome of the case, it has a way higher chance to be favorable to the people that has whose rights has been violated. So I think most district court judges in Mexico will know and understand that since President López Obrador has criticized, and we can even argue that he's persecuting judges, they will be more receptive to this type of claims, hopefully. And yeah, let's see what will happen. Thank you very much, Gamelyn. So lastly, we have Michel Hernández, who is an expert on ICT regulation. He's a professor at Universidad Iberoamericana, Ibero, and also at Universidad Panamericana. He has a BL from Ibero, and he has an LLM from King's College London. And he's also the director of Observatel, a very important NGO that also analyzes public policy in terms of ICT regulation. And he also has been very much involved in reducing the technological gap between different segments of the Mexican population. So please, Michel, feel free to talk about your presentation today. He's going to discuss what he is saying, that it's a public policy disaster foretold, the new cell phone registry. Go ahead, Michel. Thank you.
Can you hear me? Yeah. Thanks again for the invitation, Gabriel. I know we are over time, so I promise I'll be brief to leave some time to Q&A. A big thank you, of course, to the Global Berkeley Society for taking this discussion to an international level. I think what's happening in Mexico is very important. Of course, thanks to my colleagues for their interest, very interesting presentations. And thank you for the opportunity to share some ideas about this registry. I hope not to sound too repetitive, because particularly Miriam, Saiph, Grecia, and also Gamelyn already brilliantly addressed some of the adverse effects I will talk about today. So I think I will just summarize what has been said today. And yes, as you mentioned, if I had to title my presentation today, the title would be The Mexican Cell Phone User Registry, a Regulatory Failure Foretold. And hearing all of you today, I can only reinforce that idea. For me, one of the main concerns with this reform is, of course, that the consequence of not providing our personal data and biometric data is the cancellation of the mobile service or denying access to it. As Gamelyn said, that's some kind of extortion in a country where 30% of the population is still unconnected. It's just amazing what they are doing. As my colleagues explained here today, the registry was approved and championed by some legislators under the argument that it will prevent crime and particularly eradicate both extortion and kidnapping. It was presented to us as the panacea against crime. And I started wondering why most countries aren't implementing this registry if it seems to solve all public safety issues. And of course, I didn't have to investigate much. The answer is simple: because it won't work. There is no evidence that a registry of this kind will reduce any crime at all, not internationally nor in Mexico. And even worse, we already had this experience in our country just a few years ago. During 2011 and 2013, or between 2011 and 2013, we had the so-called RENOUT, which is almost the same as PANOUT, but with an R and without biometrics. So it was also a registry for cell phone users. And during those years, 2011 till 2013, extortion calls increased in Mexico, probably because the database of the registry was sold for $25 in the black market just 1 year after the entry into force of this registry. So we do have evidence of the futility of this registry to prevent crime, and still our Congress decided to bring it back, to bring back the exact same tool, but worse, because it will include biometrics now. Just for this reason, I mean that the registry will not serve its purpose at all. We can anticipate the regulatory failure. And this is by itself terrible news. But in this case, it is worse because in the process, it will restrict human rights, such as privacy and access to information and communication technologies. So for those of you who are not familiar with Mexican legislation, in our country, access to information and communication technologies, telecommunications, and broadband are recognized as human rights under Article 6 of the Constitution since 2013, and hence, authorities are obliged to promote such rights, or at least to refrain from imposing barriers to it. But please let me walk you through the additional elements that, in my view, support even more the argument that the registry will lead to a regulatory failure with catastrophic consequences. And here, the reasons are twofold. First and foremost, diagnosis. The legislators who supported this initiative and also the actual federal administration attribute the increasing crime in our country to mainly two factors: the prepaid business model of the mobile telecommunications providers, which facilitate access to SIM cards with no identification at all, and the proliferation of unregistered cell phones. Neither corruption nor the high levels of impunity that are present in our country, and Miriam discussed the numbers today, around 99% of impunity, I guess that was the number. None of these problems were mentioned in the bills, which is strange to say the least. Of course, there is no evidence to support this diagnosis by our legislators, and legislators or the actual government weren't able and haven't been able to provide any studies or analysis showing the alleged correlation between mobile phone penetration increase and the rising crime. But this diagnosis is, in my opinion, the door they found to try and justify a registry of almost the entire population in Mexico. This situation, I mean the lack of serious diagnosis, leads to the phenomenon of over-inclusiveness that is evident in this regulatory system. And I will very briefly elaborate on a simple example of such phenomenon in this case. We talked about this during the Tuesday's presentation, but I will elaborate very briefly. According to our official data, more than 60% of extortion calls originate within a prison. Please keep in mind that this reform aims to eradicate extortion calls, okay? So currently, according to official data as well, the total incarcerated population in Mexico is of around 205,000 people, and we have 295 penitentiaries across the country. So most extortion calls can be clearly identified, not only geographically, but also amongst a population of just 205,000 people, those incarcerated, of course. But the answer of our legislators is to create a registry of more than 80 million people in the country to control such population. So it just doesn't make sense. Clearly, there is no link between reality and the regulatory instrument, but neither a link between the legislators' diagnosis and the rising crime. And secondly, the undesirable side effects derived from the registry. The idea underpinning this registry, as we have discussed today, is that it will end anonymity of people committing crimes, since their mobile phones would be associated to their personal data. So, according to our legislators' reasoning, and you already mentioned this, Gabriel, today, a person willing to commit a crime will go to a local store, provide his or her personal data and biometrics in order to purchase a SIM card, or 10 or 100 SIM cards, and then use those SIM cards to make extortion calls. And the police will immediately identify and capture that individual. That's the reasoning in our legislators' view. So I think we all know that this is not the way it works, and that currently there are many ways in which people committing crimes are able to maintain anonymity, even in the presence of a biometric registry. So if this registry is finally established, we can expect, of course, a series of side effects. For instance, registered mobile phones will be highly appreciated by people committing crimes. So it is very likely that cell phone robbery will increase exponentially. Miriam already talked about that as well. Hence, the opposite effect of the alleged objective of the registry will be produced, perverse effects. Furthermore, the database of the registry will also be highly appreciated by people engaging in criminal activities, such as extortion and identity theft, as it happened between 2011 and 2013. And we have to remember that this database will include biometrics. In this way, the possible effects on the victims of identity theft would be irreversible. This, of course, places the personal data of the population at high risk, as Saiph and Garcia already pointed out. In my view, the Mexican government is not measuring the monumental task of creating a database of almost the entire population, including their biometrics and the implications and risks associated to this task. Or maybe they are actually anticipating the risks, and that's the reason this task has been assigned to the telecommunications regulator, which is an independent agency from the executive and legislative branches, of course, risking the reputation of this regulator. Suffice to say that this government does not like independent agencies. So, in addition, as I already mentioned, the registry may lead to a massive disconnection of users, since many of them won't be able to engage in this process, whether because they do not have an official ID or simply because they do not want to provide their personal data in order to have access to mobile services. And this leads us to a rather different kind of effect. And this one is very interesting because this is not necessarily a negative one. I think we are already witnessing this. I'm talking about the fact that many citizens are truly worried about this registry. And many citizens are becoming more aware of the value and the importance of their personal data. It is very interesting how so many people are looking for legal advice in order to initiate amparo proceedings, to protect themselves from this registry, and to avoid making their information available. And I'm talking about people who have never approached a lawyer or a court in their lives. And this is, from my perspective, good news, because they are activating checks and balances against arbitrary measures from the Congress. And of course, our legislators, I think, never anticipated this effect. So let's see how this situation evolves. In Observatel, we have received many messages asking for advice, and I guess, well, Grecia is here. I guess R3D is receiving many approaches from many citizens as well. So I told you I will be brief, so I will end my participation here today. Thanks a lot, Gabriel, and thank you to the Global Berkeley Society again.
Thank you very much, Michel. We really appreciate you sharing your time and your knowledge with us. I just like to point out two comments about that you just mentioned. The first one is the need for Congress to take their task to run this proportionality test beforehand, approving legislation, which actually never happens. In my understanding, there has never been a serious case where they actually run this proportionality test. And another one would be that the courts need to be more searching in order to find the actual objective that the legislation pursues, and not just accepting what the legislator says, because that's the easiest way to bypass the constitutional and judicial control, just to claim that it pursues a very important constitutional objective, even though the context, if you analyze the context, you can infer that the supposed objective is not the real one. So then again, thank you very much, Michel. Also, I would strongly suggest, if you are interested in the subject, to go ahead and look for Michel article in La Silla Rota, which where he explains in more detail what he just discussed. And thanks again. So now we'll go to the Q&A section of the roundtable. I know some of you might need to go ahead and go to your work, or so. But if you're kind enough, please stay with us, and I'll ask the first question, which more or less got an answer, but I think it needs an additional comment because people are asking this frequently. So the question is, are there viable resources for Mexican citizens to do away with this bill? And additionally, but linked to this question is, what are the next steps that civil society should take to stop further overreaching on the part of the state and the infringement of civil rights? I don't know if any of you want to go ahead and answer this question. Grecia talked about it a little bit, maybe she.
Yeah, so right now there are a lot of things going on again, well, of legal measures to take against this registry. For example, our authority on data protection and access to the information just announced yesterday that they presented an I don't know how to translate it, acción de inconstitucionalidad. So they can challenge this reform. Also, well, we make from our treaty a call to action for the agency of Human Rights Commission, so they can also present one of these. But there has been a lot of initiatives from different groups that are like, and actually I feel really happy about it. Just like Michel was just talking about, that people are really interested in doing something and taking action to protect their privacy. So civil society can make can present an amparo action. How difficult it is to translate these legal mechanisms. there is from our treaty, we're working on one, so people can use it and they can present it, and we from our treaty are going to give to take the process with them. We are going to present this action on next week. I believe it's going to be Monday or Tuesday, where people just can like download the amparo, and then they authorize us also to our treaty to give to represent them, kind of, and we're going to like take this to the courts, and it's really important that this is challenged at the courts. But also a good way to make an impact is to analyze and recognize and share all this information that all these great panelists have told everyone today, and as well like acknowledging the importance of privacy, because it's especially like most of the panelists you said or mentioned, people tend to be a little bit of careless with their data, their privacy, and they and these kind of actions can kind of help us to understand better the risk that such measures can suppose to our civil liberties, human rights, and all that stuff. So yeah, go to our treaty pages, no al padrón, or there are a lot of other initiatives, whichever you like, but also talk to your family about privacy, talk about how important that is, talk about our veto rights, share this knowledge, because knowledge that is not shared is not useful.
Thank you so much, Grecia. It is also important to acknowledge that these legal remedies do not exclude each other. So for instance, and they have different requirements. So for instance, acción de inconstitucionalidad en controversia constitucional, which are supposed to be presented by both the INAI and IFT, they are going to be analyzed by the Supreme Court of Justice, but at the same time, people, citizens can present their own amparo trial. I don't know if, Pablo, can you just clarify and maybe just talk briefly about the difference between these legal remedies we just talked about?
Yeah, basically, the main difference is what you just stated. One is entitled for any individual, and while the other is can only be presented by certain state agencies. It could be presented by the National Prosecutor Office. That could be a case. Also, it could be presented maybe by the IFETEL as well. INAI could also present it. So it's basically limited, but the effects are also different, right? We have in amparo, we have different rules. In amparo, basically the protection only, if it was the case that it would be granted as unconstitutional, all of these norms, then it would only protect the individual citizen that presented this claim. While in the case of la acción de inconstitucionalidad, if it is decided by 8 of the 11 justices that it is unconstitutional, then it will have a general effect, and it will basically invalidate the entire the norms that were being challenged. So that would be the main difference basically between these two type of requirements. But as you said also, it doesn't there's no limitation that both can be presented, and then they can both have parallel procedures basically. So the fact that one is presented won't restrict the other. No? That would be.
Thank you very much, Pablo. I think this clarifies it. So we'll go ahead to the next question, which is what would you say to those who say the government already has your access to your data, so you might as well comply? Maybe Dr. Saiph or Gizeh or Miriam. I don't know who wants to take this next one.
Saiph, I think your audio is not working. No, I can read your lips, but I cannot hear you.
Hello?
Well,
Okay, now we can
Yeah,
hear you.
we can hear
Go
you.
ahead.
Yeah.
Oh, perfect. Thank you. I'm so sorry. I think personally, it's always good to think about, well, why does that have to be the reality where the government has access to my data unrestrictedly? I think that we have to make it hard. We have to consider that it's important to make it hard for them to be able to track us, especially, for instance, related to what Gabriel was saying about how China has already implemented this type of surveillance where they have their credit scores and they're able to say, oh, you know what, these citizens are following the law adequately as we want, and so they're going to receive these certain points, and these citizens are going to now not have access to these types of services. Why do we want to make it easy to the government to be able to implement that? And so I think that it's important for us to be constantly fighting for this, and also to realize how your data can be triangulated with other sources to even give more power to the government to surveil you. And you have to, I also really liked what the others were talking about, that you have to consider maybe right now you like the government and you're fine with them having your data because maybe you like Obrador, but you have to consider what happens when another party goes into power. Maybe it's somebody that's much more authoritarian. And now you have given them already the keys to your house so that they know exactly who you are, what you're doing, and they can use that data in different nefarious purposes. And so we also have to think long-term about those implications.
may I add something else, Gabriel?
Of course, go ahead.
Just adding to what Saiph just mentioned is that this is the first time in history where governments may have access to pretty complete information about ourselves in real time, right? Never in the past, governments will have your geolocation, your biometrics, your preferences, very well known, and this is the first time technology is helping all these people to have control over the population in this sense. Yes, the government had before certain information, personal information about ourselves. For instance, the public registry of the property, where you just need to disclose how many real estate or other properties you have. And that was in a certain way by civilizatory measure to know how, richness and income was being distributed among the population, try to take certain policies that will help, the establishment of a better society. But right now we're in a turning point, and that might be seen as a dystopic future if we just give it chance to the government and other entities to have access over our information, because as it has been repeatedly said here, that information could be used for manipulation and surveillance. And the rationale behind power is not changing hands, well, that's a democratic value, but power itself will try to keep and maintain power all they can for their, for all the time they can. Thank you.
Thank you, Gizeh.
I think Miriam
go ahead, Miriam.
Yeah.
Thank you. I'll be brief. I just wanted to add or to pinpoint in terms of the purpose of gathering your biometric data, right? For example, I would feel totally confident, or maybe not totally, but more confident if this type of data was stored by INE, right? Because they would need it in order to, identification matters when you're registering and when you're voting. But in terms of security agencies and the Attorney General, I might be skeptical if they would have this type of data, right? Because the outcome or the means that they would have in order to use it or not to use it or to be hacked, we need to take that into consideration, like which type of authority will actually have this kind of data and the power that they can, deploy in having this type of data?
Of course, I completely agree with all of you. Next question, which might interest Michel, is so EFT has warned that they will file a constitutional controversy against the registry. Do you think this will be an effective resource? In general terms, or I mean,
yeah. I will answer just as Gamelyn said, as a lawyer, and it depends. Why? Because we saw this el comunicado that they issued, and the emphasis is on the budget of the IFT, and I don't like that. I have to be honest. I don't like that. The emphasis must be on the interference with their powers to pursue connectivity and human rights. It's not the problem here, and the issue that has to be raised is how this registry and how this new task that the legislators are assigning to the IFT interferes with its main constitutional objective, which is connectivity for the population, which is to preserve a human right, which is to provide access to information and communication technologies, which is to preserve competitive markets. No, and sorry, but that won't be solved with more budget. It's not. That's not the main issue.
Yes, I think you expressed it very clearly in the last event we had. You said the constitutional role of EFT is to connect Mexican citizens, and what this regulation does is exactly the opposite, because what will happen if people do not provide their personal data to EFT, I mean, to the cell phone companies and then to the national registry that EFT manages, it will be the consequences that they will be disconnected. So I think that is the most powerful argument. So this again can give us a much more clear picture of if there is a real intent to actually invalidate the law in this constitutional remedies, or if it's just to make the social pressure to go away. But actually, I do agree with you, Michel. So another question is, again, about what constitutional remedies besides the legal resources do we have? And I would just kindly remind our audience that the most basic and fundamental constitutional remedy, if you do not like what the Congress is doing, is to go ahead and vote for a different party, which I'm not inviting any one of you to do, but if you do not agree with what the Congress is doing, because courts take their time, there are no guarantees. So this is also an important reminder for people. So lastly, I would ask all of you panelists if you want to add something to the discussion. One last comment about any topic we discussed, you're welcome to do it. Go ahead, Gracia.
Yeah, I will like to add on the last topic that on the last question, and also as a matter of kind of a conclusion about, well, everybody has given their biometrics to a lot of agencies and all of that. I mean, that's why I started with the context of the surveillance policy here in Mexico. I mean, it's not a thing that only happens in authoritarian regimes as in China. It's also happening here, and it's happening now. I mean, we have Coahuila, we have Aguascalientes, we have Ciudad de Mexico, Mexico City, where they are using, we have registers of using this kind of policy of tech against protesters. There's within the March on 9th of March, the feminist march, we have evidence that some of the local government here in Mexico City use these kind of surveillance technologies against feminist protesters. So this isn't a thing about, just like Gamelyn said really well, like this is not only a thing that is going to be used against criminals. It's going to be used against its citizens. It's an authoritarian technology, and let's not forget that. Let's, like Saiph always says, let's not be just chill about giving our data to the government so easily. Also, I mean, a lot of centralized databases are gold mines for hackers. I mean, if they couldn't trespass the INE or the SATs, especially when we're talking about the lack of budget here that maybe the IFT is going to have to deal with, well, maybe the lack of budget will represent the lack of security, right? So it's also the data that you're giving, your face, your fingerprints, your voice, it's crucial for your privacy. Yeah, that is crucial for future access to other rights like freedom to protest, freedom of speech. So it's not only a matter of privacy, or not only that, the famous argument about oh well, I'm a normal citizen, I don't have anything to hide, right? Well, no, that's a kind of argument that the Panopticon government wants you to believe, and that's not what happens. That is not the narrative of democratic society. And let's not give the power to our governments to surveil us in any stage of our lives.
Of course, Grecia, I do agree with you. We need to be very much aware of our rights and defend them. And also we need to have a public discussion about this subject. And if there's somebody else that wants to share a last comment, otherwise we'll finish here. I want to thank all of our wonderful experts. Great job, guys. It was wonderful to see all of you in this context. And I will also like to thank Berkeley Global Society for hosting this event and for their continued support. Also, of course, to our viewers, to our audience. And please do not forget that there are many legal resources at your disposal. And please get in touch with R3D and also Observatel and also myself. So please take care, and I hope to see all of you soon. Goodbye. Thank you.